Welcome to Navigating Receiverships, a podcast from the Commercial Receivers Association, focused on building a better understanding of what brings companies into receivership, what happens in receivership, what makes them unique, some alternatives to receiverships, and ultimately, what happens to the business as the receivership is closed out. I'm one of your hosts, Eric Morcheski, CRA board member and CEO of Nimble Strategies. We're here today with Mark Silverman, partner at Troutman Pepper Locke. Welcome to the podcast today, Mark. We're happy to have you. Can you give our listeners a little bit of your background and who you are?
Sure. Thanks, Eric, and thanks for making some time for me today. So again, I'm Mark Silverman. I'm a partner and the leader of the CMBS Special Servicer Practice Group here at Troutman Pepper Locke in Chicago. Troutman Pepper Locke is about 1,600 lawyers and 33 offices around the country. We also have 2 overseas. And we are a full-service law firm that's focused on everything from soup to nuts in a large-scale restructuring. I also am a part of our bankruptcy and restructuring group, where we handle all matters dealing with distressed assets, both in and out of bankruptcy court.
Thanks, Mark. You've gotten to do a lot of interesting things in insolvency, especially around CMBS loans and a lot of real estate stuff. We're here to talk a little bit about a unique receivership case that you've experienced that I think I see more in Chicago than a lot of other major cities, but maybe there's an opportunity for others to use this. Can you kind of set the table of what makes this receivership unique in its filing process even, and then also, what was going on that brought it into receivership?
Absolutely. So typically our practice includes, much like other members of the CRA, the ability to foreclose and seek the appointment of a receiver for the benefit of all parties in interest during the pendency of a foreclosure case. The receivership that we're here talking about today deals with a large property in the city of Chicago, and the city of Chicago imposed a receiver dealing with life safety issues at the property. This was a property that had pieces that were potentially going to fall off. It had window issues, it had elevator issues, it had interior plumbing and electrical. It's any issue that you could possibly imagine this building had. And so it had a property owner that wasn't managing the property to the best of his ability. There were some legal issues there that perhaps prevented him from doing so. And so the city of Chicago decided that it was going to petition the municipal court on its own to appoint a receiver. I'll pause there and give you an opportunity to ask some more probing questions, but otherwise I'm happy to continue.
So this was, and maybe I misunderstand it a little bit, but basically it's an alternative to eminent domain.
Correct. So it's not quite eminent domain because the property owner is still the owner of the building. The issue is that during the pendency of the municipal case, the receiver is the one that's tasked with actually maintaining the property. So everything from if there's a roof leak, if you need to replace windows, if you need to replace elevators, any type of maintenance on the building, anything that touches on the building needs to get resolved. And the way that the receiver works is not by necessarily getting funding from any particular party. Rather, the receiver gets floated what are called receiver certificates and receiver liens. So from that standpoint, the receiver has the ability to do the work at their own pace, at their own expense, and then file accountings, which are similar to receiver reports, but file accountings, which are then subject to objection and approval by all parties and by the court. And the way that this typically will then result is, so if, for example, a receiver spends $100,000 repairing a property, they get a receiver certificate in the amount of $100,000 plus a reasonable interest rate. It gets floated as a first priority lien that takes subject to real estate taxes, but nothing else. So if there is a mortgage on the property from a senior secured lender, it would go away if you complete the foreclosure. So the intent of these municipal receivership programs is really not to deal with skyscrapers or other large buildings in a major metropolitan district. Rather, it's to deal with properties that are in other areas of the city where you can put some sweat equity into a building and then be able to own it through the receivership process, as opposed to allowing some major corporation come in and gentrify certain neighborhoods. And so there's a real public good element to the general concept of the municipal receivership statute, but how it was used here was slightly different. So in this particular circumstance, there really was no lender involved. The lender was no longer really having anything to do with this. There was also some other issues in the property being subdivided in certain places. And so it really set itself up nicely for a municipal receivership to come in and actually do the lion's share of the work. And so our client here was the receiver. The receiver, before our engagement and involvement, did everything that the receiver was supposed to do as it relates to the building. He white boxed a bunch of floors, redid plumbing, redid electrical, replaced windows. I mean, just countless other things that were done at the property. Prior counsel with the receiver got all of these receiver liens approved by the court. They were then perfected when we were engaged after dealing with some other issues. And so the way that the receiver was able to navigate the case in this proceeding was to then go and say, okay, now that I've gotten out of the municipal court, the property owner is either back in or I'm no longer the receiver. We now have these receiver certificates for the amount of money that we've expended plus interest, and we now need to foreclose. And so the question then came to me, which is, hey, you do foreclosures, right? Can you foreclose on a receiver lien? And the answer is, well, sure, but it's a slightly different process than your typical Illinois mortgage foreclosure law issue. And so what we had to do is create a process to be able to get this in front of a foreclosure judge and be able to take it through and get to an ultimate conclusion, ultimate resolution. What ended up happening here is that we were able to get the foreclosure done. We were able to strip all the liens and effectively get clean title to the property through a foreclosure sale. And then my client was able to then sell the certificate of sale to a third party to then finalize and consummate the transaction. What's now going on in the case, even though we're no longer a party to it, is that the person who purchased it is attempting to rezone it to redevelop the site. And so it's actually hopefully will turn into a very nice project and a very nice building at some point in the not too distant future.
So, for lack of a better term, the receiver ends up playing developer a little bit in this scenario. So they come in, they actually do, obviously with all the life safety issues, it needed basically a complete gut job of the building. And then they flip it. They don't obviously have a purchase price because they were coming in as the receiver, but they are all liens, would all other liens be wiped out as a part of this process? So there's nothing else. Does the receiver cover the cost out of pocket for everything leading up to that though? So if it's a long-term play, I mean, you have to have some decent sized pockets to cover those costs, right?
That's exactly right, Eric. And that's frankly why this is really only used in smaller types of circumstances and infrequently in the larger office building kind of context, because the carrying costs will bleed any reasonable or rational company or person dry. It's very expensive to maintain these older buildings. And so the receivership statute doesn't necessarily work, and municipal receivership statute doesn't necessarily work in all those contexts. But what happened here is that the receiver was able to work with a variety of different paths of financing and funding sources to be able to bridge that gap to get to a conclusion, and worked on goodwill, frankly. And a lot of folks were willing to go through the process with him and delay payment until the conclusion. And so it works out in the end because all of the liens that would have been placed on the property are really subsumed into the receiver certificates and the receiver lien, which are then all approved by the court and signed off by the court. And so ultimately where you get to is it's really similar to a mechanics lien foreclosure. Mm-hmm. So you are effectively proving enhancement value, even though that's not part of the requirement, but you're effectively foreclosing on that lien amount as opposed to whatever the value of everything else would be.
Fascinating case. So out of pure curiosity, you went through this with what I think was actually a decent sized building, as far as I know. It's not, some little house essentially, but would the receiver consider doing it again, right? Like, does the receiver
it's not for the
walk out
faint
of
of
there
heart.
Going, that's the first and the last time I'm ever going to do this, right? Because that's a telling story, right?
It is. And the reason why it's become so interesting and why I think folks look at it as an interesting case study in what the Municipal Receivership Act can be used for is for the exact reason you mentioned. It's not for the faint of heart. It's going to require a person that's got some gumption and has some ability to really think through, as you said, as almost a developer, to really look at this from a recovery standpoint. And so when you're looking at a lot of these large buildings, the issue that you have is most of them have lenders that are involved and you're dealing with a defaulted borrower. And so the lender is going to come in and appoint a receiver and going to take on a lot of that burden for the benefit of the parties to be able to get the receiver funding to do the work, to do the project, to get the building into compliance, to then get it sold. In the vast majority of cases, that's going to be how these work out. There's a handful of buildings throughout all of the various metropolitan areas where there may not be a lender, and you may just have a borrower that's either passed away or that's no longer available to be able to handle this. And that's when the municipal code can come in. And I don't know that there are a lot of receivers that would want to get involved to this magnitude. I know that my client certainly would welcome it. I think that there are a lot of folks that would welcome it if they were given the opportunity. It's a great way to work with the community and work with the city and get to a resolution that benefits the city of whatever city you're in.
Mm-hmm.
And I think that it can lead to some really good results and some really creative strategies for improving buildings that otherwise wouldn't have a purpose. So I think that it's good, it's creative, it gives folks an opportunity to really work hand in glove with the city. And you just have to have willing participants on all sides. And if you can't get willingness, you have to fight your way through it, and it can be very cumbersome.
And presumably there are construction loans or some iteration of almost debtor in possession loans that would be available. And if you're a lender, you have to look at it thinking, well, there's no first mortgage on this that I'm then bringing that in on. And so maybe there's an ability to seek financing that could fund some of these that would make it a little less pressure on a small receivership shop. So it's to me, like I've said to you before, I think this is a fascinating story. It's a little bit of an offshoot of the typical receiverships that we see, come in, but it's, presumably a very valuable asset to a city that might have a need that they don't know how to solve. So they
Yeah,
should call
that's
Mark
exactly right.
Silverman, and Mark can explain to them how to solve that issue.
It's funny because, again, I've been practicing in this area. We do a lot of receiverships. We're very fortunate to see a lot of deals and have a lot of good looks. This is one that certainly, when it crossed our plate for the first time, we were looking at it and going, well, this is different, but this is workable because the lien act is the same. And so when you really kind of factor in what is a lien, whether it's a mortgage, whether it's a mechanic's lien, whether it's a receiver's lien, or whether it's a municipal code receiver's lien, they all operate in the same way. And so the process is the same, but the conclusion is slightly different. And so how you build up to the lien, for our purposes, was less relevant than just kind of the actual tackling of what a perfected lien does in the state of Illinois. And so it was a fascinating case and a fascinating opportunity to really add some impact to the city and leave our mark on the city, which was kind of neat.
And presumably there wasn't a concern that when you brought this to the foreclosure proceeding, that would be an issue, correct? That
No, we were not at all concerned. It's the courts understand this. We're not the first folks to bring a foreclosure on this. I think at the size and the magnitude, we may have been kind of near the first in time on that.
Mhm.
But it was very easy to explain. These were amounts that hadn't yet been paid. They're secured by the property, and the only way to monetize that is to get to a sale. And just like you would for a sale on anything else, get to a sale of the asset. And once the asset is monetized, the receiver lien gets paid, and everybody else, their liens go away pursuant to the Illinois mortgage foreclosure law. So it's really no different than just foreclosing down on any other junior or subordinate lien.
Yeah. So you walked through this whole process. When you look back, what would some of those lessons learned have been from your perspective if you were to go through this again?
The exact same thing that we tell all of our receiver clients is make sure that your accountings are incredibly detailed, make sure that your time and tasks are incredibly detailed, have receipts, have understandings, have everything that you can. And our client, again, this predated our engagement on this, but our client was very organized in this, but it still took a Herculean effort to have the receiver liens be approved by the court. The court goes through everything. And in order to give a lien of that magnitude, the court needs to be very sure that everything was performed, that the amounts are correct, and all of that. So that's step one. Step two is making sure that you understand the foreclosure process. And so understand that there are going to be twists and turns, but that there are requirements along the way. And so it's getting everything buttoned up so that there are no loose ends with the court, making sure that service is complete, that you've recorded your service affidavits, that you've filed them, that you've issued them for unknown owners and non-record claimants, that you've recorded a lis pendens against the property. So all of the foreclosure 101 basics, they all need to be complied with at the very outset of the case. And then to get through to the conclusion, you can still navigate through alternative methods of sale. But here, what made the most sense was to work through the judicial foreclosure process and then credit bid. And if there's no other bidders, then you take as the credit bid. And so when you're dealing with properties that have such significant amounts of continuing work that need to be performed, it's tough to find third-party buyers that are willing to get saddled with huge amounts of deferred maintenance, et cetera.
So is there anything else that you think listeners should take away as they go through these or as they consider them within their own city? I mean, I guess one question before we get into that. How does, presumably in this case, the city decided this was the right path for that building, right? It's not that the receiver was out going, that building's really decaying. I should take this to city council and propose they do this. Or how does
It's the
that,
former.
yeah.
Yeah, so the city of Chicago is the one that asks for the receiver. The receivers aren't out there picking buildings and attempting to take them off. That would be a little askew. But I think, again, the purpose of the statute here is to benefit more of the city and to give folks the ability to come in and be able to develop in neighborhoods and be able to have some ability to earn sweat equity into properties that are otherwise going to be unused. And the city of Chicago needs this as a service because it's taking these properties and putting them back online. And so that's the underlying purpose of this. This, again, was, I think, a very unique and unique circumstance. And so the city was the one that was pushing the ball on this.
Yeah, I mean, I can think of about a dozen properties in downtown St. Louis that could probably use something like this. Part of the problem is how big they are. I mean, there's one in particular that everyone in St. Louis knows is is hanging over our head, and it's a 1,200,000 square feet, and
Oh, wow.
that would be a difficult one to to undertake and to completely gut and renovate.
For
Um,
sure.
yeah, so there's I'm sure St. Louis is not the only one that has these going on. There's cities across the country with buildings that someone needs to do something about. I guess in the receivership, how do you push this forward? It's probably about educating legislatures on what all of their options are, right? And the same way we talk about receivership and ABCs and bankruptcy, is really about tools in a tool belt and understanding which tool is best to use at which time. I think that probably is what would be the best course of action, is my assumption, is
Absolutely.
teaching.
And there are advocacy groups too. So
Mhm.
across the country, there are advocacy groups looking to implement legislation in various different places that are similar in scope and effect to what we have here. I don't know the status of that, but I'm sure there are others that can talk very broadly and narrowly on this topic to the extent that the CRA is interested in hearing about it. But to the extent that there aren't statutes in major metropolitan areas, there should
Mhm.
be. It's
Yeah.
a very valuable tool, and it's something that I think adds a lot of value to the city and gives the city some comfort that properties are being taken care of, being maintained, and being turned into something that can actually be an economic driver through taxes and otherwise, as opposed to just being dilapidated or boarded up or otherwise out of service.
Mhm. So I think this has been a fascinating conversation. Is there anything you want to leave listeners with or make sure that they understand about this process?
Yeah, these are bespoke scenarios. So unlike a lot of other situations where there's a lot of different ways to kind of go down the same path, here, this is how you have to do it. So you need to actually go down the path. You need to be able to make sure that step one is completed before step two. There are no shortcuts. There is no ability to truncate the process. And each of these are going to look slightly different. And the reason is because you're going to be dealing with liens that are issued at different times and different manners, clipping coupons at potentially different interest rates for different periods of time. So the way that you'd even run out interest calculations is going to be different because the dates on which the liens were created are different. And so it's a complicated process, and it's not, again, not for the faint of heart, but it's something that with counsel that can really fully understand the process with you and navigate the path forward together, you're going to end up with really unique and cool results. And I think that's it makes it a lot of fun, and it's one of these that leaves you feeling good at the conclusion.
Hopefully someday when we're hosting a conference in Chicago at some point, you can give us a tour of the building and show us all that was accomplished and how it really changed that perspective in that building and perhaps even in that surrounding area.
That sounds great, Eric. We look forward to it.
Thanks, Mark.
All right, appreciate it.
Thank you for joining Navigating Receiverships, brought to you by the Commercial Receivers Association. Find more information at commercialreceiver.org and catch every Navigating Receiverships podcast by subscribing through your favorite platform today.